The social worker's investigation. Come with me and let me explain how you might be able to fix this horror story. Juvenile dependency cases usually begin in two ways. First, the social worker, generally an emergency response worker, becomes aware of the suspected child abuse, which is usually reported by a third person. California, like most states, has a long list of mandated reporters of suspected child abuse. Teachers, doctors, therapists, daycare providers, or any other person or persons can call anonymously and report child abuse to the social worker. For example, your child attends school and the teacher notices some sort of injury to the child, or the child tells the teacher that he or she has some sort of injury caused by someone in the home. And that's where the county social worker's investigation begins. The second case starts generally with some sort of police involvement and your children are present. For example, you are pulled over in your car for suspected driving under the influence and your children are in the vehicle. More than likely, the police will contact the social worker hotline. The social worker will come out and take a child into custody. The social worker is supposed to advise you of your right to speak to an attorney, but this is rarely done. In the criminal court system, if the police don't advise you of your right to an attorney before you speak to them, your statements could be excluded from evidence. Not so in the juvenile court system. Your comments can lead to not only you losing your children, but in some cases could also lead to you being criminally prosecuted. And in most cases, social workers are all too happy to testify against you in a criminal proceeding. During the initial investigation of the social worker, several things can be done. First, the social worker can immediately initiate a court case. Second, the social worker may conduct a further investigation which may take a few days to several weeks. We recently had a case where the social worker went to the mother's home and got the mother to agree to remove the children for 30 days. The mother signed various forms, including forms to have the mother drug tested. Then the mother called me. I immediately revoked all of those releases for information and advised the worker that my client would not be doing any drug testing. The social worker informed the mother that if she followed my advice, she will file a case against her in the juvenile court. In the end, the children were returned and no case was filed. Again, don't talk to the social worker without consulting an attorney. And do not sign any forms. This is a tactic used by the social worker to gather evidence against you. So why do I share this great information with you? I share with you this information so that you will know what can be done when things go wrong in the courtroom or with the social worker. I realize you're likely seeing this because you have questions and concerns about your own matter. If your matter happened here in California and you're thinking about your situation, I invite you to pick up the phone and call me. You know, I answer questions like yours almost every single day, and I'd love to talk to you. You can reach me at 888-888-6582 or email me at v@vwdlaw.com. We will file the right legal documents and briefs to get you the best chance at getting your child back. That's all for today's video. Have a wonderful day.